Okay, so in this next section, we're going to start looking at the Convention Against Torture, and in particular, the definition of torture. So firstly, looking at the legal context of the history of torture, we know that torture is mentioned in the UDHR. It's also mentioned in the four Geneva Conventions. These are international humanitarian law, or laws of armed conflict, and in this thing called Common Article 3, which means that all the four Geneva Conventions have the same article, which does mention the prohibition of torture. We have it mentioned in Minimum Standard Rules for Treatment of Prisoners, and of course ICCPR. Now, the important one here is the emergence of the convention in 1984, when we see the CAT Convention, which is now the Convention Against Torture, in 1984. We also see that it gets mentioned in the Rome Statute of the International Criminal Court is one of the methods of genocide or crime against humanity, widespread and systematic acts of torture or attacking of people of a certain group using torture amounts to an international crime. We're going to focus on the 84 Convention. So firstly, it's important to note the title is a lot bigger than what I've been saying. Most people just commonly call it the Convention Against Torture. But the full title includes Convention Against Torture and other cruel, inhumane, or degrading treatment or punishment. So we see there are lots of elements. So we have torture. We've also got cruel and inhumane treatment and punishment, or degrading treatment and punishment as well. So we are talking kind of separately about 3 or 4 different things: torture, cruel and inhumane, degrading, and punishment as well. And we'll unpack those distinctions in the next section, in section 3. So we see it's got 171 ratifications. That means that there's just 20 countries, or about 23, 24 countries which haven't ratified it. So it's quite widely ratified. But in the region, in the Asia-Pacific region, we see there are a number of countries which have it: Malaysia, Singapore, Bhutan, Brunei, Myanmar, India, and North Korea have not yet ratified it. And Thailand was quite late to ratify it in 2007. Now, the actual background to the history of the treaty itself, so it appears in 1984 and it comes into force 3 years later, but it kind of appears in 1984 because in the 1970s was a period where there was lots of torture which kind of gained international attention, being used particularly in Latin America, but also to a certain extent in Greece and Turkey. Now, in Latin America, you had military dictators in control in most countries, and they were using disappearances and using torture against political opponents. And we're talking about thousands of cases of people tortured. In Greece and Turkey and Europe, it was a bit different. There were still military governments, but torture tended to be used more in the prison system. And it was still used by the military and political opponents. We see that these kinds of cases led towards the international community saying we need to have some kind of human rights treaty which is going to prevent torture. So that's why it appeared in 1984. Now, the Convention Against Torture has an optional protocol which allows for visits and investigations. And that has 91 ratifications. That's about half the world's population there. But in the region, only Philippines, Cambodia, Mongolia, Maldives, Afghanistan, and Sri Lanka have ratified that and allow those individual investigations. Okay, now next, so the first thing we want to look at is the definition. Now, the definition against torture is one of these more complex definitions. We need to unpack it because it has many elements. We need to understand what each of these elements are. So it says the definition of torture, and this is the first time torture is defined in international law. Actually, maybe it was defined in the European Convention. I have to check it up. It's one of the very early definitions of torture in international law. It says torture means any act by which severe pain or suffering. So the first part is this idea of it has to be severe pain or suffering. Now, there's no kind of objective measurement of severe pain and suffering because it is kind of subjective. What may be painful to some people are not painful to others. So, like people involved in in boxing matches or in mixed martial arts, I mean, that must be very painful, but they don't see it as painful. So there is a level of subjectivity there, and they don't try and define it. But also that pain and suffering can be physical or mental. It just doesn't have to be physical, hurt the body. It can be put under mental strain of being threatened or your family being threatened. The next element is it has to be intentional. So if it's just done by accident, say a policeman spilling a hot cup of coffee on someone, that's not torture. It may be painful, but it's not intentional. It'll be intentionally inflicted. Now, torture also must have a purpose. Just if a soldier or a policeman just wants to hurt someone because they are a mentally deranged person, isn't torture. It's still assault or battery or whatever. It's still a crime, but it's not the crime of torture, because torture must have a purpose. And those purposes are things like obtaining a confession, intimidating or coercing that person, or any reason based on discrimination. So we see these different kind of purposes there. Most commonly, torture is used for either acts of discrimination, so you're torturing people because they're a member of an opposition group or a marginal or a minority group, or for confession, which is mainly used by police to try and extract a confession from someone. Now, the next important part, it has to be inflicted at the instigation or consent or acquiescence of a public official. So torture can only be done by public officials. But this does mean teachers, nurses, doctors, alongside police and soldiers, can commit torture. Now, the inflicted, instigated consent or acquiesce means that even if that public official allowed that pain to occur, it's still an act of torture. The public official doesn't have to actually inflict the pain themselves. They can consent or allow someone else to do it. Okay. And then it can be done by anyone else acting in an official capacity. And this can mean, for example, non-state armed groups, which are working in an official capacity. Now, this last line is a controversial one, and it does tend not to be kind of taken that seriously or used that much, because it says it does not include pain or suffering arising from or inherent lawful, incidental to lawful sanctions. Now, lawful sanctions means here that there are lawful ways of inflicting pain, say Singapore and Malaysia, which uses the cane to hit people, or Middle Eastern countries which may have amputations or stonings. Now, the world does now see that corporal punishment and painful corporal punishment should be considered, it should be defined as torture or cruel punishment. So while some states like Singapore and Malaysia, which may use caning or other forms of corporal punishment, if they ratified, would use this this final sentence to justify that, the world now kind of considers that they just don't take that seriously. They don't use it in terms of determining what is or isn't torture. Okay, so we have these main elements here, which we've talked about: severe pain and suffering, intentional, physical or mental, with an objective by a state agent. Okay. We've done that. Now, let's just put this into practice by giving this example of, say, is gay conversion therapy torture? Now, gay conversion therapy is where a person suspected of being gay may have to do severe psychological training, or may even have electric shock therapy, in the belief that their gayness can be cured and they become heterosexual. Of course, we know this is all wrong. This is, there's no truth about this at all. But in the case of, say, what happens if we assume it's a young child, say a young boy or girl of 16, and their parents take that child to some gay conversion place to convert their sexuality? Would we consider this torture? So let's go back to the definition. So there is severe pain or suffering there, if we're assuming it's using things like electric shock therapy or other kinds of severe psychological abuse. Now, but one issue here is that if that's, say, an adult who consents to be part of the therapy, then it wouldn't be torture because that person consented to it. Much like, a boxer or a mixed martial artist consents to be hit by another person. So, but if it's a child and that child may not consent, you have to say, well, it does fit severe pain and suffering, which can be either physical, like electrical shocks, or it could be mental. Now, the next challenge here, of course, is it's intentionally inflicted, which means that the doctor who does the electric shock intended to inflict severe pain and suffering. Now, this can be questionable because that doctor may think they're just doing a medical procedure. So we know that when you have an operation, it's going to be painful. But that doctor who does the operation isn't torturing you, because even though they know they're doing you'll be under severe pain and suffering, it's done for your health. It's not done to just create severe pain and suffering. So there's going to be questions about the intentionality of it. Okay. Next one is the purpose. And so this could be a little bit tricky, but it's not, the purpose can't be confession. But it could be punishing them for an act, the act of being gay or lesbian, the act of being LGBT. Or it could even be the third case, for a reason based on discrimination. The reason that child is having that conversion therapy is because of discrimination based on sexuality. So we could see there's a purpose there. Okay. Now, next, infliction at the instigation of consent of a public official. Now, doctors are public officials because that doctor has a certain permit, a certain power authorized by the government to undertake medical procedures as approved by the government. So it would fit the public official. So gay conversion therapy could be considered torture as long as the issue of the intentionality is sorted out. If that intentionality, like they're inflicting the pain and suffering as a kind of punishment for being gay, then it would be torture. If that doctor really believes that this is a medical procedure which is going to make that person better, then there may be an argument that maybe it's not torture. Now, whether it's torture or not doesn't mean that it's legal, that it's proper. Most countries around the world recognise this is wrong. Many countries recognise this as torture and have banned it or criminalised it. And so it's still a very wrong thing. Whether it's torture or not is still open a little bit to debate. Okay, we'll stop that section there.